The test for legal sufficiency is whether, considering the evidence in the light most favorable to the prosecution, a reasonable fact finder could have found all of the essential elements beyond a reasonable doubt. According to the Manual for Courts Martial, the elements of Article 92, subparagraph 3, UCMJ, are as follows. A. That the accused had certain duties. B. That the accused knew or reasonably should have known of those duties. C. That the accused was willfully, through neglect or culpable inefficiency, derelict in the performance of those duties. Hello, my name is Major Mike Webb. 3 years ago, we were hit with a virus that was met with silence and spread unchecked. And yet, after September 2022, when Bloomberg Business Journal had announced that the latest results of the National Assessment of Educational Progress had revealed historically large drops in math and reading scores for U.S. public school students, despite a call for a national declaration of emergency, none had come. However, it is a foundational principle of administrative law that judicial review of agency action is limited to the grounds that the agency invoked when it took the action, such that if those grounds are inadequate, a court may remand for the agency to offer a fuller explanation of the agency's reasoning at the time of the agency action. No speculation. According to the Ballotpedia article, placed in juxtaposition to the 5 arguments for closures of schools, there are 8 main types of arguments against school closures, 7 of which both sides generally concede as fact from a pandemic, and only differ as to how much weight should be accorded to those factors. First, all agree that school closures posed significant unintended consequences. Second, all agree that school closures and reopening plans have disparate economic effects. Third, all agree that these school closures and distance learning exacerbate in a digital divide. All agree that they should reopen schools to protect the economy, and it is of some significance that in addition to contemporaneous reports that announcements of lockdowns had resulted in a tenfold increase in unemployment claims in the state of Virginia, the equivalent of a Hurricane Katrina in every state, just a little more than 2 weeks before the closing of public schools for 2 years, it had been announced by World Health public authorities that they were in the process of reopening their economy and reopening schools in China. However, by October 2020, around 1.6 billion, or 90% of children of the world, had at some point been kept from attending school, when everything from preschools all the way up to colleges and vocational programs, schools in 188 countries were shuttered, an unprecedented disruption in the history of education. By October 2020, the number had been reduced to just 34 countries, affecting more than 577 million students. And even worse, around that time, UNICEF Chief of Education Robert Jenkins was warning that some 25 million children around the world were in danger of never returning to a classroom again, while as many as 463 million children worldwide were unable to access the internet to seek education opportunities online. And yet, further, as early as March 2020, when public schools were beginning to close in Arlington, Virginia, Forbes magazine had been reporting that the pandemic is expected to have enormous economic consequences, and a research project from Cornell Law School and the Coalition for Prosperous America assessed more than 37 million, mostly lower-wage U.S. jobs may be vulnerable to short-term layoffs. And Forbes magazine had reported at that time, as early as March 2020, that school closures were having a devastating impact on global education, such that, according to the latest UNESCO figures, some 1.3 billion learners across the world were not able to attend school or university as of March 23, 2020. And according to Ballotpedia, placed in juxtaposition to the 5 arguments for school closures, there were 8 main types of arguments against school closures, which we can examine one by one. based upon what, with reasonable inquiry, had been known at the time that the Arlington Public School Leadership Light Chairperson Monique O'Grady and Interim Superintendent Cynthia Johnson had made their executive decision to cancel in-person instruction, just as some had argued that school closures were necessary to prevent the spread of the virus. Opponents of school closures had argued that school closures are ineffective in preventing the spread of the virus. With two diametric opposites, clearly both sides could not possibly have been right. Considering a duty for due diligence and dereliction thereof, to the degree that negligence involves a failure to perform a duty, actual malice exists when the defendant knowingly commits misconduct or when engaged in action with reckless disregard. And clearly there exists an established methodology to determine whether or not a disease is infectious and how infectious or not it is. By this method, if a party on either side had not performed this very basic calculation, especially after 3 years of pandemic declaration, that conduct would rise to the level of at least reckless, if not far more than mere acquiescence or silence or failure of an officer to perform a duty that does not make one a participant in a conspiracy unless he acts or fails to act with the knowledge of the purpose of the conspiracy and with the view of protecting and aiding it or himself or herself. And at least in the military, leaders are aware that before beginning hazard identification, the limits of the assessment must be defined. You must know what you are looking at least according to DAPAM 385-30. The risk assessment consists of the first two steps of the risk management process. In step 1, individuals identify the hazards that may be encountered in executing an activity in quantifiable terms. In step 2, they determine the impact of each hazard on the activity. The risk assessment provides for enhanced situational awareness because you want to be able to see the threat. This awareness builds confidence and allows soldiers, units, army, civilians, and organizations to implement timely, efficient, and effective protective control measures, reasonably calculated. In the tactical environment, intelligence preparation of the battlefield, or IPB, is a systematic, continuous process of analyzing the threat and environment in a specific geographic area. And in step 1 of the IPB process, the G2/S2 identifies characteristics of the battlefield which will influence friendly and threat operations, as well as identify gaps in current intelligence holdings. For details on this process, we can consult FM 34-130. Similarly, in intelligence, tactical, or strategic, at least according to military planners, the primary focus of the intelligence warfighting function is to provide timely, relevant, accurate, predictive, and tailored intelligence that focuses missions and operations. Arguably, any effort to neutralize or counter attempts to develop a timely, relevant, accurate, and predictive tailored information would of necessity be considered counterintelligence or counter to our efforts to defeat terror directed at the United States. And the actual malice exists when that defendant knowingly commits misconduct or when engaged in action with reckless disregard under the rules stated in New York Times v. Sullivan. No one would disagree that reopening schools should be the highest priority, or that school closures violate students' constitutional rights. However, proponents of closing schools had turned a blind eye to reports from China by the World Public Health Authorities that had determined in a credible clinical study that school-age children were not only at a low risk for infection of COVID-19, but also had found that the incidence of COVID-19 in China had been less than the flu amongst children, for which we do not close schools for 3 years. And from 19 times more cases than had yet been reported in the entire U.S. by mid-March 2020, 1,800 teams of at least 5 epidemiologists, a very credible and robust study examining 55,924 laboratory-confirmed cases, could not find even one case in which it appeared that a child had infected an adult. In the trial of Adolf Eichmann, a fugitive of justice for 15 years, the court had concluded the excuse given by the accused that all he did was to pass on a message following orders is not plausible because undoubtedly he knew the value of the tale of the administration of the tonics to which he had put his signature.
This message was approved by Major Mike Webb. Honest.